everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's easy for me to say. This week's contract tip has to do with you as an affiliated licensee of a broker. You as a licensed real estate agent, engaging in real estate yourself. What I mean by that is you as an agent buying or selling, leasing or renting or exchanging property yourself in your own name, whether that be a personal residence or an investment property. And basically a couple of issues. Number one is that because you are a licensed agent with a broker, you must notify your broker of everything that you do relative to real estate. So even if you are an investor and have investment properties, you still must notify the broker. And a couple of issues to touch on. One is GREC rule, and these are all part of license law. GREC rule and the Georgia Real Estate Commission license law in Georgia, the rule 520-1-.11, licensees acting as principals. And part one of this, paragraph one of this states that written notification to the broker. No licensee shall be permitted to list, sell, buy, exchange, rent, lease, or option, or offer to list, sell, buy, exchange, rent, lease, or option real estate. So basically, no licensee shall be permitted to engage in the practice of real estate or make any offers either in individual or multiple parcels in the licensee's own name without first advising in writing the broker for whom the real estate licensee is acting. So what that means is if you are going to list a house that you own, again, personal residence, investment property, land, anything like that, if you are going to list real estate or purchase real estate, you must first, before engaging in a listing agreement, in a buyer brokerage agreement, in any of the customer acknowledgments, or in any purchase and sale agreement, before you sign any of those documents, you must first notify your broker in writing of what you are doing. That would be some sort of letter or email or notification or notice advising the broker that you own the property or you are a partial owner of the property, you are going to list it, sell it, so forth and so on. You must do that prior to signing a listing agreement. So the signed listing agreement or the signed buyer brokerage agreement or customer acknowledgments in and of themselves does not satisfy this law. It clearly states that the licensee must first advise in writing the broker for whom you are acting prior to being permitted to list, sell, so forth and so on. So that's the first thing having to do with you as principal buying or selling your house. Make sure you guys do that. And if you are a broker watching this video, you brokers make sure that you keep those written notifications from your agents when they are notifying you of their intent to engage in real estate with their own properties. Additionally, when you are, per the GREC media advertising license laws, part of those, there's a lot to that, but part of those state that when you agent are principal in a deal, well, every marketing and advertising must be done in your broker's name and under the direct supervision of your broker, but that's a whole nother video. But specifically, when you are the agent is principal, meaning you are the buyer, seller, landlord, or tenant, and you are engaging in real estate and you are advertising or marketing that property, everything that you do must be in a manner indicating that you are not a private party, but that you are actually, you're not an individual, that you are a licensed agent working with a broker. So it has to be done in the broker's name. The fine for violating that is $600. And it also goes on, the license law also goes on to state that every associate broker, salesperson, community association manager, so forth and so on, is prohibited from advertising under the licensee's own name to buy any property or to sell any property or rent or lease, without notifying the broker who holds your license of doing so, and without doing so in that broker's name, even if you are not under a brokerage engagement. So what that means is, and you'll have to check with your own broker, it would be your broker's policy whether or not, if you're going to sell your own house, again, let's just use that as an example, whether it's your personal residence or an investment property. If you're going to sell your own house, you need to, number one, notify your broker before doing anything. Then you need to check with your broker on their policy to determine, does your broker require that you sign a listing agreement, or will your broker allow you to sell the property without a listing agreement? Regardless of what your broker's policy is on actually signing a brokerage engagement with the broker, you still must first advertise, you still must first notify, and then you still must advertise that property. Even if you don't have a listing agreement signed, for example, in this example, you still must advertise in the name of your broker. Additionally, if you hold a real estate license, then you must advertise that you do hold a real estate license. And you can do so by saying such and such name holds a real estate license in the state of Georgia, or Georgia real estate license number such and such. A lot of times we see sign writers that say agent owner, but you must disclose that you are a licensed real estate agent. Now this holds true even if you are an inactive agent. If you have not relinquished your license back to the Real Estate Commission, but you're inactive, your license is not with a broker, you are still beholden to license laws, and you still must advertise that you are a licensed agent in the state of Georgia, and I would do so by putting your license number on there. And in a purchase and sale agreement, you're required to do that anyway. Additionally, the broker must give you consent to advertise the specific property. And so again, you just have to advertise in the broker's name. More on agent as principal. So additionally, a question could be, why do I have to tell my broker that I am marketing a property that I own if I'm not paying a commission? Again, paying your broker a commission or not, that has to do with your broker's policy on agent as principal within the firm. But per license law, per Official Code Georgia Annotated Section 43-40-29C, that law states that in order to protect the public, it requires a licensee to comply with its provisions, whether acting as an agent or as a principal. So basically, license law requires that all brokers review the agents or the licensees. If you're affiliated with a broker, license law requires that your broker review all of your real estate activities for compliance with the law, whether or not that activity is for a public person that the broker is representing or for you as principal. Therefore, any contracts must be run through the broker, regardless of the policies regarding commission and payment. The contracts, whether it be a listing contract, buyer brokerage contract, or purchase and sale agreement, must still go through the broker for a compliance check. So once you have a real estate license in the state of Georgia, any and everything that you do regarding real estate must run through the broker if your license is with a broker. There is a lot of other information regarding trust money and handling security deposits and earnest money with you, agent as principal. But again, that's a video for another day. A lot of times also, a lot of licensees that have investment properties or were full-time real estate investors prior to getting their license, they feel that, regardless if it's not my personal residence, but it's my business, another way of providing income, it's really not necessarily up to my broker to be privy to my personal real estate interactions and dealings. because I'm not necessarily taking a commission or charging a commission, so the broker's not due a commission, so to speak. And again, that has to do with the broker's policies. But license law states that the broker is liable and responsible for your actions as a real estate agent, whether you're principal or helping someone else. And especially your broker is liable for any funds relating to that real estate transaction. So everything must go through a compliance check. So bottom line, again, there's a whole lot of other issues pertaining specifically to license law regarding handling trust funds and those kinds of things. But the purpose of this video is twofold. Just to remind you that especially you must advise your broker prior to listing or prior to buying, prior to renting, prior to leasing. You must advise your broker in writing of your intent to do that, whether it be a personal residence or an investment property. So make sure you do that. Brokers, make sure you keep those copies of those written information, that written advisement from your affiliated licensee. And the second thing is that all marketing and advertising must be done in the name of your broker and under the direct supervision of your broker. And thirdly, you must remember that in all marketing and advertising and on your contracts, you must disclose that you are a licensed agent in the state of Georgia. So thank you so much for watching. Hope this contract tip helped you out a little bit. And I am Dana Sparks, qualifying broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.